You said that those motions that were put forth are they're not Brian Kohberger specific. They are general. They're death penalty. They're about the death penalty in Idaho. So why is that the case? Like when I first read those death penalty motions, that was my issue with them. I'm like, these don't hit the mark. They're not about Brian Kohberger.
Yes,
They're
they aren't.
just about the death penalty. So who
Exactly.
are they to be arguing in this trial court about the death penalty in Idaho? What good's that going to do them?
Because if he is convicted, there will be a mandatory appeal. And in order to appeal these issues, to raise constitutional objections to the death penalty, you have to preserve them below. So there are a number of problems with the death penalty statute, like for instance in Florida, that exist in every death penalty case. So in every death penalty case, you're going to file a bank of motions challenging the death penalty, so that if the person is convicted and sentenced to death, you can then raise them on appeal, and they have been preserved because they've been raised below.
Okay, so you're saying that they worked very, very hard to write all those motions and submit them on the deadline, because if, and the magic word is if, he's convicted and receives the death penalty at appellate stage, they will need those things to be in the record.
Exactly. This aggravator does apply to every death penalty case, every first-degree murder case, and therefore it's arbitrary. This is a winning argument, in my opinion, to the U.S. Supreme Court at some time in the future. This is a very strong argument against the arbitrary application of the death penalty as it is written. EHAC should not be in any statutory death penalty enactment. They should eliminate EHAC as well as CCP aggravators, because they apply to everything and it makes it arbitrary.
What's
if
the
people
CCP
were cold, calculated, and premeditated. So that exists in every death penalty, every first-degree murder case. Now, so if somebody is pro-death penalty, because there's going to be people here like, I'm for the death penalty. If you're for the death penalty, then you should want death penalties to stick. You should want them not to be overturned in the future by a future Supreme Court of the United States. And if you are for the death penalty, you should be against the EHAC and CCP aggravators, because they are built-in bombs that will overturn death penalties in the future by some future U.S. Supreme Court, because they are arbitrary. As a matter of logic and fact, these are very weak aggravators that apply to everything. And if you're for the death penalty, you should want to eliminate them. But instead, people want to expand it, the death penalty. And so they want it to apply to everything. And therefore, they're making their statutes unconstitutional because of the political appeal. If you're for the death penalty, you should be against these aggravators.
That's very interesting. And isn't it so different to hear Steve saying in no uncertain terms that this is a winning argument and it's an argument for the future? I haven't heard any commentator say that at all. Everyone has been talking about how all of these motions were just denied by the judge and how the defense is messed up, etc. No one has given this point of view at all. And clearly it was... these have all been written based on a best practice that not even a best practice, a required practice.
Okay, and this is one of the book is Death Penalty Design's maximum due process. Here's another concept. If you have a traffic ticket, it's like you're entitled to a hearing before a magistrate and pay the fine. If you have a misdemeanor, you're entitled to a little more protection. A felony, a lot of protection. Death penalty, you're entitled to maximum protection, maximum due process. And so in that case, that's why a capital case is so advanced, because a capital practitioner, a death penalty defense attorney must file every possible motion. Okay, so a lot of these motions, they say there's difference, there's weakness, there's weaker ones and there's stronger ones. All right. To me, the CCP and the hack arguments are very, very strong. And in fact, that is the basis for future death penalty jurisprudence being overturned in the U.S. Supreme Court, is this very argument. Now, the trial judge ain't going to do it, and maybe the Idaho Supreme Court ain't going to do it. In fact, like when I was arguing this in the Florida Supreme Court's not going to touch this because they're all appointed with the litmus test to supporting the death penalty. The target audience for this motion is the U.S. Supreme Court.
Has to go all the way there.
Right. And here's what's going to happen, too. So, okay, it may not be Kohberger's case that's going to win it. Yeah. It's going to be somebody with a marginal case with a much better fact pattern. And then what's going to happen is then the Supreme Court's going to say anything with an e-hack aggravator is going to be struck down, and Kohberger's going to be in that group, and he's going to be entitled to resentencing.
That's how it works. Now, Brian C. Kohberger, by and through his attorneys of record, and hereby moves this honourable court for an order striking the state's notice pursuant to Idaho Code 19-4004A on the grounds that Idaho's statutory and constitutional guarantee to a speedy trial prevents the effective assistance of counsel in death penalty cases.
That's interesting.
Yeah. Idaho requires all criminal defendants to be brought to trial in 6 months from the arraignment on an indictment pursuant to statute and its constitution. In Idaho, the right to a speedy trial is defined by IC 1930-501 as it was at the adoption of the Constitution. The Idaho Constitution guarantees a speedy trial except where there is good cause for delay or the request for postponement came from the defendant. 2. The Idaho Constitution requires a fixed amount of time constitute undue delay. This court should adopt the 6-month line adopted by our legislature. B. A defendant in Idaho can never request additional time without losing his right to a speedy trial. A capital case cannot be prepared in 10 months. 3. Idaho cannot force a defendant to choose between his rights.
Okay, so this is an excellent motion. This is a good one. I'll say this is very good. So here, the first concept. This lays it out. I mean, this is a good lawyer who wrote this, because to me that summarizes it in a very easy to understand logical syllogism, right?
Well, I even get it. I even get it. I've liked this one since it came out, and I've been wanting to ask you about it. So.
Well, but there's a lot of complication here. I'll try, but and I can expand into the complication quite a bit, but let's just stick with that syllogism, because that's where that's the framework for the argument. So the thing is that you shouldn't be forced to choose between rights. Okay, I have the right to a speedy trial.
Yeah.
And I also have the right to say the right to remain silent, for example, or I have the right to be presented with the evidence against me. I have a right to a full and prepared and adequate defense. Okay, so let's take the first one and the last one: the right to speedy trial and the right to a full and adequate defense. Right, I have a right to it. Well, what they're saying here is that there is based on what the death penalty requires of the defense attorney. There is no human way a human being defense attorney can adequately prepare for trial given the statutory speedy trial time of 6 months.
Yep.
All right. And when I ask for more time as a defense attorney, that is deemed a waiver of your speedy trial right. So just the mere asking for more time waives speedy trial.
Yep.
Therefore, I'm being forced to choose between a fair trial, a right to have a prepared defense attorney, and the right. I have to give up my speedy trial rights in order to get the other right. Or I have to go to trial unprepared. So either way, I'm giving up my rights. So the death penalty is unconstitutional because it's forcing me to choose between those two rights. That's a pretty good concept. I like this concept.
And that's exactly what happened. I remember, because he was forced. His hand was forced. He had to waive his right to a speedy trial because there was so much left to do at that point in time. And people weren't even talking about the fact that in the background, they had to do the mitigation work, right? So
that's a good point, because, and if you read death penalty designs, mitigation is required. So you must prepare mitigation. To not prepare mitigation is ineffective assistance of counsel. And mitigation is that's one of the major costs involved in a death penalty system, is that every time the state requests death, even if they eventually plea or get life, there must be a mitigator hired. And that's a minimum $25,000 to $50,000 right up front. Yep. And it takes a lot of time and a lot of effort. The thing is that the system, as it's designed, requires inhuman levels of competence and preparedness. Louder for
those in the back, Gosney. So many people are so angry about how long this has taken, right?
Well, but my friend, it's 2 years. 2 years. My friend Rosemarie, who's who is our lead capital trial attorney in Volusia. Now she's with the Jose Baez firm, and she's handling a couple death penalties for Jose Baez. She's great. She's the best trial attorney I've ever been around, bar none. And she says that when she got a death case, she would say to her client, we're 2 years away from a trial, at least. And some jurisdictions, it's much more. That was in Northern Florida. It depends on jurisdiction, but minimum 2 years. So this is at odds. There's no way to prepare adequately for a death case. There's so much complication, because remember, we're talking about maximum due process. Look at the motions that are filed here. Every one of these motions, if there is a possibility of a motion, you must argue it.